Welcome back to the second panel of our webinar on defense rights in evidentiary procedures. My name is Laure. I am Legal Director for Europe at Fair Trials, and welcome also to those who just joined us. I will give a few quick words of introduction in case you missed this morning's session. So Fair Trials and our national partners, the Croatian Law Centre, the Irish Council for Civil Liberties, Human Rights Monitoring Institute in Lithuania, the Helsinki Foundation for Human Rights in Poland, Civil Rights Defenders in Sweden, and our academic partner KU Leuven. Together, we explored over the last 2 years whether existing rules and practices on the admissibility of evidence are sufficient to address violations of procedural rights in evidence gathering procedures, whether they're sufficient to offer meaningful, effective remedies and to prevent future violations of procedural safeguards. So we've been looking at how remedies can really give teeth to the EU procedural rights directives in the sense of remedies, meaning that violations of procedural safeguards actually lead to concrete consequences. And you will all have received our report, hopefully. And this morning we discussed the key findings of our research in relation to the regional case law as well as national practices. And we heard this morning from the former European Court of Human Rights Judge Paolo Pinto de Albuquerque, from Marcin Wolny of the HFHR in relation to Polish law and practice, and Professor Michele Panzavolta from KU Leuven. And some of the key points I think that emerged from the discussion this morning, very interesting discussion, was around the case law, the current case law of the European Court of Human Rights, where opinions were expressed that it doesn't sufficiently robustly protect the rights of the defense and the accused, and that there's a real need for change in the Grand Chamber's approach in particular in relation to evidence obtained illegally in violation of Article 6.3 of the Convention. We also heard about the need to adopt red lines and consistency in approaches towards exclusion of illegally obtained evidence, and also concern that where national law is not protective enough and does not guarantee the right to an effective remedy, as in Poland, this may jeopardize mutual trust between member states. And as my colleague Ilse also said, this is the beginning of the discussion. So now I have the pleasure of continuing the discussion and moderating our second panel in this webinar. So now we will really draw from the discussions from the first part of the day and look to establish whether EU law and guidance on effective remedies for violations of defense rights are sufficient, or whether more action may be needed, and what steps and what shape these steps could take at EU level to ensure that violations of EU law are properly addressed and remedied in a manner that disincentivizes future violations and makes the EU procedural rights directives more effective in a way to strengthen mutual trust. So for this, I'm delighted to welcome our speakers. And also, and then I will turn to questions. So please, during the presentations, don't hesitate to use the Q&A function to ask any questions, share any comments you may have. And we have made sure to have time after the speakers' presentations to turn to these. So please don't hesitate to raise them during the presentations. And we will turn to you later on. So first, in terms of run of show, we will hear from Dr. Matilda Pogorzelska. I'm sorry for the pronunciation, Matilda. Matilda is a legal researcher and project manager in the EU's Fundamental Rights Agency. And Matilda deals with criminal procedural rights and judicial cooperation in criminal matters. Previously, Matilda worked as a case processing lawyer in the European Court of Human Rights. And we're absolutely delighted that Matilda is here today to present some of the key findings from the FRA's research challenges in the implementation of the procedural rights directives, and how the right to an effective remedy, as foreseen by the Charter of Fundamental Rights, can be relied upon in this context. Thank you, Matilda, and over to you.
Thank you so much. Sorry, thank you so much, Laura, and good afternoon, everyone. Many thanks for inviting us, much appreciated. So just to go to our research to present these issues, FRA is still lucky enough to have been able to research almost all of the procedural rights directives. We were asked by the Commission continuously to work on those, and always while researching the implementation in practice of certain provisions, we would ask questions about remedies. So these questions were always asked, not always answered, I must say. But I will get back to that. We started in 2015 with rights to interpretation and translation and right to information. Then we moved on to right to access to a lawyer. Then last year we have published our findings on Directive on Presumption of Innocence. And now we are as we speak, we're working on procedural safeguards for children who are suspects and accused persons. So I would say that by now we have a good overview of how these procedural rights are implemented in EU member states. The first two directives, interpretation and translation and information, we did research by means of desk research in all then 28 member states, but also we did a selected number of cross-checks with organizations and practitioners, meaning we asked mainly defense lawyers and judicial practitioners whether what we're learning from a desk research, so from a sometimes perfectly drafted law in paper, is actually true. And what we also did, we circulated a questionnaire to EU-LITA members. It's a European Union Legal Interpreters and Translation Associations. So they were also able to give us an overview of their practice. We published a report in 2016. What we focused on. Obviously we did not focus on evidence as you see from the titles of the directives, but every single challenge, what is there, it will impact later on the course of the criminal proceedings, the course of even evidence gathering, the course of admission of evidence, because obviously we know if the defendant is kept in the dark, meaning that doesn't understand the language or is not provided with the information, it has impact on further proceedings. So what we focus on the necessity and the timeline of interpretation and translation, notion of essential documents. You might remember that essential documents have to be translated, and back then member states did not know what kind of documents are essential or not. So it was we checked with practitioners and also with law. Communication between suspects, an accused person and their legal counsels, quality requirements, right to information, and of course available remedies. As I say, we always ask about remedies, so this is something we always focus on. We found out several challenges, I might say, as highlighted to us by practitioners. For example, it was very often highlighted by legal defense lawyers, a confidentiality issue, use of different or the same interpreters for confidential consultations with defense lawyers, and then for questionings. And this was seen as a problematic by defense lawyers, while legal interpreters and translators were clearly in favor even of using the same interpreter for the whole proceedings. So this seems to be seen like that by both professionals. We also focused on condition of working condition. And we have accounts from legal interpreters and translators that were presenting a rather dark picture of reality, that their working conditions are not ideal and they are not paid enough. So this is what we found out. What is the main takeout? What we suggested as a FRA, because obviously we can have our opinion, we can suggest, we can recommend, and this is what we did. That member states should consider developing practical guidance on how to assess the need for interpretation and translation. And it should be really easy to access with straightforward guidance, because police officers, they sometimes also left in the dark. They don't know if this person speaks the language, is the level of language good enough or not good enough. So it should be somehow regulated, or at least a checklist should be developed. That EU member states should consider introducing a specific list of essential documents. That EU member states should consider ensuring that suspects and accused person received at the very beginning of proceedings explicit information about the availability of interpretation for communication with their legal counsel, because this seems to be a problem. And obviously, as we all know from work in this area, if there is no communication with legal counsel, the course of the proceedings will be hindered by that. So this should be ensured, and also specific safeguards to ensure that the confidentiality is there of communication between suspected and accused person and the legal counsel, and it's not jeopardized by the use of the same state-appointed interpreters. As I mentioned before, this was an issue. The legal interpreters, they do not necessarily agree with that. However, lawyers see it as an important thing also psychologically for defendants, because if they see the same person during the confidential consultation and then during the questioning, they might not feel safe during these proceedings. And also we did, in the same report, we did studied and we did presented our findings on rights to information, when it kicks off. And in general, member states can be divided in two main groups: those that require information to be provided when a person acquires a status of a criminal suspect, and those that require providing information about rights to individuals when they are arrested at this very moment. I will not go into the details, but we do have this in our report: when and how information is provided, whether the individual needs are taken into account, use of legal language, simplifying information, what we found out. And this information and this finding has been always confirmed later on, that written form does not always serve to achieve the goal. So this is what we know. On the content of information, back then when we researched, different member states informed about different rights, but we need to also remember that it was the research was done in 2015. So I will not be presenting this information, as we do realize it might be outdated by now. Remedies. We always ask about, as I said, about remedies. And research findings show that in most EU member states, it is possible to challenge failures or refusals to provide information in the same way as one would challenge any other procedural deficit in the course of criminal proceedings as a result of authorities' action or inaction. So there was no, back then, specific remedies. It was a normal remedy that you would always lodge in the course of criminal proceedings. And of course, some of them might constitute a ground to start appeal proceedings. Some of them would be somehow remedied during the course of first instance proceedings. So this is what we found out in this research. And then in 2018, we went deeper. Why we went deeper? Because we had a field work, meaning we interviewed a number of legal professionals and also defendants at the request of the European Commission. And we mainly focused on access to a lawyer, but also asked questions about right to interpretation and right to information. So then we researched 8 member states: Austria, Bulgaria, Denmark, France, Greece, the Netherlands, Poland, and Romania. And what we wanted to know how, of course, these rights are respected in practice. We focused on national proceedings and national practice. We interviewed 170 criminal justice professionals and 83 defendants who were arrested in the course of the proceedings. What we found out, again, I'm coming back to the same right to information. Defendants are not always effectively informed about their rights. So this was confirmed. Most practitioners and defendants agree that defendants receive information, but they sometimes just not able to understand the information for several reasons. There are barriers, legal jargon or language barriers, lack of education, these things. And what might be the most important here for the topic of this event is that at the initial stage, and this we had basically confirmed by almost all legal professionals and defendants, defendants are questioned as witnesses, and then this information is somehow included in a case file, although we know it should not be. And obviously here we also asked about the right to remain silent. But I will go back to this questioning as witnesses, which of course we know it poses a lot of problems from the defense point of view, because defendants who are questioned as witness, they do not enjoy the protection that directives accord to them. So law enforcement authorities, there are cases when law enforcement authorities question a person as a witness or informally ask them questions, even when there are already plausible reasons for presenting charges. And this is what we found out. And the law enforcement practices, sometimes they establish these informal practices so that the self-incriminatory statements made as witnesses can later be used. How they are used? Defendants then, after the initial questioning as a witness, when they learn they are defendants now, they are questioned again, obviously with seemingly all the safeguards that they are, but the legal enforcement authorities would ask them whether they stand by what they said previously. And then the police officer would refer to these statements. So this is how it's included in the case file, or so-called police memos, when it's just written by a police officer. Police officer is a witness then, but the statements somehow are in the file. So this is something important to realize and important to be aware of. Also, the respondents highlight the crucial importance of defendants having access to a lawyer, to legal assistance from a very, very beginning. And this is also coming back to us over and over again, because what we found out is that defense lawyers are basically the first line of defense for the defendants. If the defense lawyer is present, the likeliness of violating or challenging the procedural rights is smaller, as simply as that. So this is what we take from this research. Then we have again carried out a field work, this time on a presumption of innocence, also at the request of the Commission. And we again ask legal professionals about right to remain silent, right not to incriminate oneself, and obtaining evidence by compulsion. So again, our previous findings were confirmed. What we found out again, that the defendants might not understand that they have this right to remain silent. Defendants might be somehow encouraged, even by a very friendly manner, even with a friendly manner. We find out from legal defense, from defense lawyers, that they know that the police officers in a very friendly way could ask defendants before formal questioning. Look, we're just talking now, so please tell us what you know. It will help you. It might shorten the proceedings. The judge might look at you more favorable. So all these subtle ways of coercion, basically. So we know from the legal professionals that they are there. Lawyers state that the police frequently make false claims and deceive suspects to pressure them to self-incriminate. And we have it confirmed by basically defense lawyers from all the member states researched. Something very important. But interviews from Portugal emphasize the good practice stemming from the Portuguese criminal law. That statements made before the police are never admissible in the court unless defendants so requests. This is one of the safeguards that we found out. It's a good practice. It stems from law, so law already is good. What a lawyer from Cyprus told us, and I want to quote here, that persons without legal training facing a police officer sometimes feel that they have to say something, and the police will write down everything they say and can use it against them in court. The police need to explain that silence does not mean guilt. We as lawyers, I'm quoting a lawyer from Cyprus, we as lawyers must have time and means to speak to our clients before the police have the chance to take their testimony. Often the right to remain silent is only explained to suspects once the police have secured all the testimony they required and have completed their investigation. This is a serious abuse of the procedure. And I was quoting now Cyprus lawyers, but we heard that from other lawyers as well. So we heard about promises of milder sentence, of faster proceedings, or we heard that police would say, if you don't say anything, it will look bad. You will look as a guilty person. So this is something to be aware of. But also the findings show, and some lawyers, especially from Belgium, point that, okay, it's correct, it should be like that, that law enforcement officers warn defendants about advantages and disadvantages of exercising the right to remain silent. And obviously, if somebody remains silent, they might face a pretrial detention. And this is confirmed by everyone. So lawyers, especially from Belgium, as I say it's only fair to make defendants aware of that. They need to understand that they do not have to speak. But if they choose to remain silent, indeed the proceedings might be longer and they might end up in pretrial detention. This is how it is. The vast majority of interviews report that if defendants remain silent when there is material evidence against them, this will in general result in a conviction and often a longer sentence or in pretrial detention. So something to also be aware of. When it comes to another incriminating evidence, such as data stored on electronic devices, the majority of interviews, for example, from Austria, Germany, Italy, and Poland, agree that defendants are generally not obliged to provide it. For example, phone PIN or computer or email passwords. defendants can only voluntarily provide evidence that may affect their the course of the criminal proceedings here. And judges and prosecutors agree that it's the job of the police to obtain this evidence, to obtain access to secured phones and password-protected computers. A prosecutor from Germany, for example, recalls a public discussion on borderline cases involving the unlocking of mobile phones using fingerprints or a face scan. So there was a discussion pending, and maybe it still is, whether this represents an active participation of a suspect, or which would be illegal, or passive representation, such as, for example, sampling of blood, right? So this is an ongoing discussion, as we understand. In Austria, for example, a lawyer observes that some defendants, namely those who are innocent, provide their passport during the first contact with the police, provide their PIN for the phone, or unlock their phone, because they say they have nothing to hide, and or they just too intimidated, or they don't know that they can refuse. They don't need to do that. So this is what we learn about that. And again, many interviewees, primary lawyers, but also judges, identify early access to defense lawyers as a key safeguard of all the defendants' rights, but including also these rights to not to self-incriminate and to remain silent. And again, while asking these questions about every single of this, we always ask about remedies. And in general, what we learn, there are no specific remedies. In generally, national laws just foresee normal remedies, as in the normal every single criminal case, meaning either a complaint or an appeal when there is a ground for appeal. So this is what we found out in a nutshell. Thank you so much. If there are any questions, please go ahead.
Thank you very much, Matilda, for this overview of the research on implementation of the Procedural Rights Directive that you've been conducting, including in relation to remedies, and highlighting some of the challenges that are faced early on in the proceedings and how they impact the course of criminal proceedings. It's very interesting in particular to hear about the informal practices that you raised, something that we also documented in our report that we've just finalized, and also the fact linked to these practices that there's little oversight. There's a lack of procedure to challenge the legality of evidence at a pretrial stage, and also issues, sort of compounding issues in terms of implementation of rights, where you also have a lack of access for the defense to early access to case file, which means that it makes challenges even more difficult. So interesting to hear as well, good practice from Portugal. And maybe we'll have an opportunity to come back to the access to mobile phones. It's something that has been raised in a case in the European Court of Human Rights, the Minte against France case. So on this issue specifically. So it'll be very interesting to follow the developments there. So thank you very much, Matilda. Next, we will hear from Fabian Lobot. So Fabian works in the Directorate General for Justice and Consumers of the European Commission. He works in the field of procedural criminal law and deals with the procedural rights of suspects and accused persons in criminal proceedings, as well as mutual recognition of judgments in criminal matters. Fabian holds a master's and a PhD in EU law from the University of Panthéon-Assas in Paris, and is also he was also a Max Weber postdoctoral fellow at the European University Institute in Florence. So we're very honored to welcome Fabian today, who will share with us an update from the European Commission's about the European Commission's work around the implementation of the directives and specifically around remedies. Thank you very much, and over to Fabian.
Thank you very much, Laure, and thank you for organizing this very interesting seminar, and for inviting me to be here on behalf of to represent the European Commission here. So first of all, I would like to say that I'm indeed, as you say, working in the Commission, and I would like to present you what we are doing in this field, but I will also share some personal remarks on the developments of the case law and what can be done at EU level. So I will try indeed to see what could be done at EU level to improve the question of admissibility of evidence, possible exclusion of evidence when there has been violation of procedural rights in criminal proceedings. We have seen this morning how, and also in your report, how difficult and sensitive this topic is. It is very difficult to have clear case law, even from the European Court of Human Rights on this subject. And also, we must say that in the EU legislation itself, namely in the Procedural Rights Directives, there is no much rules on this. So what can be done? We first can reflect on what currently exists, and what currently exists is the Charter and the Procedural Rights Directives. And it could be envisaged to have a more protecting case law stemming from the Charter itself, or stemming from the interpretation of the Procedural Rights Directive case law, which could be the one of the European Court of Justice. On Article 47 of the Charter, I will not develop very much on that, but the case law on the right to an effective remedy is limited first by the scope of the Charter, which to be applied needs that it is in the framework of implementation of EU law, and we know that the case law on this is not yet very clear. So we have seen that there has been some developments on some cases, for example, on data protection, and it is interesting to see that the ECJ is trying to develop some case law on remedies, and especially on admissibility of evidence. Also it's not yet very accomplished, as you put it in the report. So the next question would be whether it would be possible to develop case law on the basis of the existing procedural rights directives. These directives, they all contain, let's say, a standard provision on remedies, which ensure that in principle member states should put in place effective remedies for violations of the rights provided for in the directives. The difficulty is that this provision is quite broad, quite vague, and refers to the notion of effective remedy, but without more precision being given in the directives. However, sometimes, and it was mentioned also by Matilda just before, some provisions do need some direct remedy. For example, in the Presumption of Innocence Directive, you have the right to be present at the trial, and there is a specific remedy in the directive itself in case this right is being breached. For example, on the right to interpretation also, there is the possibility to challenge a decision finding that there is no need for interpretation. So here and there are some specific remedies, but this does not resolve the question of admissibility of evidence. It is interesting to note that in these directives, the Commission had proposed some rules on admissibility of evidence, which were quite limited, but in the Presumption of Innocence Directive, there was in the proposal of the Commission a rule on violations of the right to remain silent and violation of the right not to incriminate oneself, which were in Article 6 and 7 of the proposal. Any evidence obtained in breach of this article shall not be admissible unless the use of such evidence will not prejudice the overall fairness of the proceedings. So it was a try to have a principle of exclusion with this overall test that is also present in the case law of the European Court of Human Rights. But this did not fly in the legislative process, and the result, which is now in this directive on presumption of innocence and also in the access to lawyer directive, is a paragraph stating that without prejudice to national rules and systems on the admissibility of evidence, member states shall ensure that in the assessments of statements made by suspects, so in violation of their rights, the rights of defense and fairness of the proceedings are respected, which is a very broad and very quite vague, I must say, a provision. So it is obviously difficult to impose on this basis rules on the admissibility of evidence, bearing in mind that member states and that the legislator itself has decided to preserve these rules on admissibility of evidence. And therefore, from the point of view of the European Court of Justice, when interpreting those directives, it will be difficult to derive specific rules on admissibility or exclusion of evidence, the legislator having decided not to insert such rules. What I must say also, and this is very important in what Matilda said before, first of all, what needs to be ensured also is that the rights itself are not violated on a systemic basis. The rights to access to a lawyer, the right to remain silent, the right not to incriminate oneself. And the Commission is trying to assess all the legislations of the member states. Unfortunately, we're not in capacity to assess all the practice that may affect and that may violate the directive, but already if the legislation of the member states is in compliance with the directive, it would help to ensure that you don't arrive to the stage of having evidence which is on a systematic level on breach of these provisions. And on this, this question of the scope of the directive is very important. We see that all member states do not conceive the scope of the directive in the same sense. Some have quite narrow scope, which means that they will apply the directives only when they consider that the stage of criminal proceedings is reached. And this can lead to practices such as the ones described by Matilda, of trying to get statements from persons who are in reality and de facto suspects, but that are considered by the national authorities in line with the national procedures as mere witnesses or non-yet suspects, so person interrogated on the spot. And of course, this causes a lot of problems. So I would say the first step in the implementation of the directive is to ensure that they are properly implemented throughout the criminal proceedings, which are not to be defined entirely by the member states. The criminal proceedings become, according to the directive, whenever a person is notified by official means or otherwise, so it can be a very factual status of being suspect. So I think this is an element from the current directives. What can be done next? Can we improve the situation also by let's say more legislation on this aspect, and especially on admissibility of evidence? First of all, I would like to say that there are a lot of challenges. The challenges, the first one is the reluctance of the member states. So I have pointed that out already in the current directives, but it is clear for the moment that the member states almost unanimously don't want to have rules on admissibility of evidence, and even less, let's say, on exclusion of evidence for violation of. Why is it so? Because first, they have they consider that this should be dealt at the national level. There are traditions in procedural criminal law, and those traditions should not be let's say, affected by rules that will be adopted at EU level. So this is a first element that we have to take into account, because obviously the Council is co-legislator and we cannot adopt a legislation at EU level without the Council. And you need to get a majority of the member states, and there is even in Article 82 the possibility for the member states to consider that their traditions are being affected. So this is the first element to be careful with. The second element is the wording of the legal basis itself. Article 82, paragraph 2 of the treaty. Indeed, there is a specific mention of admissibility of evidence, but the wording is mutual admissibility of evidence between member states. So you have this notion of mutual admissibility, which means, and the question I think is still open, does the EU has a competence to address all violations of procedural rights and to have rules on admissibility even at domestic level? As for the Procedural Rights Directive, they apply in purely domestic proceedings, or is the competence of the EU limited to admissibility of evidence when there is a cross-border element? And this is reinforced by the fact that Article 82 also has this wording that the EU can adopt directive to the extent necessary to facilitate mutual recognition and judicial cooperation having a cross-border dimension. So all these elements also have to be taken into account. And for the Commission, who has the role to propose and to initiate legislation, that means that we have to show to the member states that there are indeed problems in cooperation between judicial authorities. There are problems of mutual recognition that derives from the lack of EU rules. And this has to be clearly demonstrated. And final challenge that I would like to cite is the divergence of national rules. There are a lot of let's say, opposite views, as was explained also this morning. Some member states have a principle of free assessment of evidence by the judge. Other member states have rather strict exclusionary rules. And it is very difficult also to reconcile these views in terms of content of a possible proposal. What would be the red lines in such a legislation? It was also what is the approach to be chosen, and how to determine what should be exactly in this proposal. There is a need for a balanced approach. I think if legislation is to be proposed at EU level on this, it cannot be only about exclusion of evidence. It has also to take into account the developments of mutual recognition instruments, or at least instruments that facilitate cooperation, such as the European Investigation Order, also to facilitate the exchange of evidence between member states, while protecting the rights of the persons involved in criminal proceedings. So all these questions remain open, and the Commission has decided this year to launch a study to address all these aspects and to see really what are the problems, including practical problems, linked to the lack of rules at EU level. So this study is planned to last for 1 year, and we should have the result of this study by the spring or beginning of the summer next year. And on this basis, we will assess if there is a need and if we consider that the Commission consider it necessary to propose a piece of legislation or any other initiative on this topic. Thank you.
Thank you very much, Fabian. Well, hopefully our report will provide some inspiration to the Commission on these questions. Thank you also for highlighting the limits in EU legislation in terms of admissibility rules, despite the specific remedies that are foreseen in some of the directives, including on the presumption of innocence. And it's interesting as well that you've linked that to the difficulty to expect more guidance from the courts, the regional court, the CJU, in relation to remedies. It's also interesting to hear about the need for further implementation of the existing procedural safeguards, in particular in relation to scope, where there is improvement that can be should be made, and we can envisage maybe later in the questions. And also flagging the challenges raised, the reluctance of member states, and at the same time, the fact that we have more and more measures, EU measures on cross-border evidence exchange, the European investigation order, the e-evidence, which is in the pipeline, which also seeks to promote the mutual exchange of evidence, and of course the European Public Prosecutor Office role in this context. So just linking it back as well to the point that Marcin raised earlier, that need to have common standards in order to reinforce mutual trust and support these different mechanisms. So this leads us really to Luca De Matteis. Luca is Senior Legal Officer at the European Public Prosecutor's Office, the EPPO. He is acting Head of Legal Service since 2020. And previously, Luca was at the European Commission's Anti-Fraud Office, OLAF, in Brussels, and team leader responsible for the activities related to the setting up of the EPPO. He was previously also seconded national expert at the General Secretariat of the Council in the unit dealing with criminal justice and fundamental rights. And before joining the EU institutions, he was also a judge in Italy, specialized in criminal matters for 10 years. So we're delighted to welcome Luca today to talk to us, share with us some insights and perspectives on how questions relating to the admissibility of evidence are being addressed in the context of the EPPO, which has launched its operations earlier this year. And I just read a report that there are already 1,700 crime reports recorded by the EPPO and 300 investigations opened. So it would be very interesting to hear some insights from you, Luca. Thank you.
Thank you, Laura. And I can also immediately start by updating those figures, because the crime reports have passed the mark of 2,000 and the open cases are nearing the 400 mark. So the activities is picking up speeds quite rapidly, as had been anticipated. So we're trying to make do with the resources that we have and hopefully be able to deliver on these important investigations, considering that until now it is estimated that the total damage to the EU budget caused by the offences on which we have open investigations ranks in the order of around 4 billion euros. So we're dealing with a substantial portion of the EU budget that needs to be protected from crime and criminals. Good afternoon to everybody. As Laura said, I am currently the head of the legal service at the EPPO, although of course, like my colleague Fabian Lobot, I'm also going to be speaking largely in a personal capacity to give you some insights about how this question of evidentiary remedies, and in particular evidentiary remedies from our point of view in terms of cross-border acquisition of evidence is perceived at the level of the EPPO, also in light of the first few months of activity. Perhaps I would like to start to making reference to what Fabian has just told us about the state of play of the reflections in the Commission about these questions, making also reference to my previous professional experience during my time at the General Secretary of the Council, I was one of the persons responsible for supporting the negotiations on the procedural rights directives, and particularly starting with the directive on translation and interpretation and right to information, and the other ones that followed later. And I was there when the majority of the council got rid of the Commission's parts of the initiative where there was a strong link between violation of the principles set out in the directive and an overarching set of remedies that would be applicable in all member states. And when this reference was largely replaced by a reference to the duty that each member state has under the applicable fundamental rights instruments, ECHR and the Charter, to provide for effective remedies, but doing so in accordance with their national laws, and as we understand also from the findings of the research that Matilda has explained to us, not only national procedures but also national habits and informal understanding of these procedures. One element which I find interesting to go back to is the question as to whether the power of the EU to legislate under Article 82 is limited to cross-border proceedings. And here a reflection which was circulating back at the time where we did start to look at the translation and interpretation directive is that it's really difficult to give a definition of what a cross-border proceeding is, simply because what is a national proceedings can easily become later on a cross-border proceeding, even at the execution stage, if the person that is being touched by repressive measures by a court moves to another member state and needs there to be reached by the consequences of the judgment. So what may look like a purely national proceedings may hide or present at a later stage a cross-border measure which as such was not evident before. So indeed, it is difficult to limit the intervention of EU law to a set of criminal proceedings, as if to create a parallel criminal procedural law applicable to a subset of investigation. So from this point of view, I understand that that indeed the reflections are delicate, and of course the political sensitivities of member states have not changed a lot since 2009 until today. We at the EPO are, of course, extremely interested in this development, if only because we are on the, if you will, on the receiving end of the uncertainties that the current legal framework presents in terms of the effect of a violation of fundamental rights on admissibility of evidence, and in particular on cross-border admissibility. From our point of view, it is difficult enough having to do with 22 different legal systems, which is what EPPO does. As you know, we are a single prosecution office at EU level that investigates and prosecutes in each of the 22 participating member states, largely based on national rules. And we therefore have to carry out our investigative and prosecutorial activities in 22 different member states. Now, that's already a complicated enough legal environment. If to this we add that in those sectors that would be interested by the statutory standard setting activity of the EU, we do have an uneven level of reception of the obligations deriving from those acts of EU law, and in particular here we're looking at the Fundamental Rights Directive. The picture becomes even more difficult for us to deal with. So from this point of view, we have all the interest in ensuring that our activities take place in as even a playing field as possible. And the question of the fundamental rights is one that is, of course, of primary importance for the EPPO. For two reasons. First of all, we're a prosecution office, and as such, our prime task and our prime responsibility is to uphold the rule of law. So as such, the rule of law includes all the rules that pertain to fair trial rules and to the rights of, to upholding the rights of the defense. It is in our prime interest that proceedings are carried out to the highest procedural standards at all times across all member states. And more pragmatically, however, we do face the question of how uneven implementation and application of the standards on procedural rights affects our ability to gather information and to ensure that it is circulated cross-border to other jurisdictions. And the reason for this is quite evident. The EPO is competent to investigate and prosecute crimes affecting the financial interests of the Union, so fraud to the EU budget, but also customs fraud, large-scale VAT fraud, all financial crimes which have, if you will, ingrained in their very nature a cross-border element. Although it is not essential for the EPO to have a cross-border element present in its investigation for it to have competence, it is so that by nature our investigations carry with themselves the necessity to deal simultaneously with more than one legal systems, and to whereas our investigations are rooted in one jurisdiction, because each of our investigation takes place through one of our European delegated prosecutors in one of the 22 participating member states, it is far from rare, I would say quite the contrary. It is extremely frequent that this delegated prosecutor will have to relate to the legal system of another member state in terms of the fact-finding activities that make up the investigative phase and later the prosecution phase. Against this necessity, the EPO regulation, as you know, is extremely poor in terms of rules on how this cross-border acquisition of evidence should take place. There is a mechanism designed in Article 31 of our founding regulation, Regulation 1939 of 2017, which essentially aims at going beyond currently applicable instruments of mutual recognition for the acquisition of evidence, and to set up a system of direct cooperation between the delegated prosecutors acting on behalf of the EPO in the different member states in terms of direct assignment of specific investigative measures from one delegated prosecutor to his or her colleagues in another member state, as if these investigations were taking place in a single legal area, which is a term which was present in the initial Commission proposal but later fell out. But the idea is that the EPO acts as a single office in all 22 jurisdictions, which means that indeed cross-border acquisition of evidence is done in such a way as to have materials that can freely circulate between the member state where they have been actually acquired and those where the investigation and later the prosecution and trial take place. Against this backdrop, whereas we do have rules on the mechanism, we do not have rules on the admissibility of that evidence, which means that the EPO regulation lacks clear provisions in terms of the standards that this cross-border acquisition of evidence done according to this completely new model of direct assignment from one delegated prosecutor to another should respect. The only rule that is present in the EPO regulation is that which prevents a national court before which the EPO brings one of its prosecutions to declare evidence acquired in another participating member states inadmissible on the only ground that this has been acquired in another member state in accordance with a different set of procedural rules. Which of course means that the court is free to declare it inadmissible for a number of other reasons. So you understand that, of course, this being the picture, and one of our main preoccupations in the coming period when our activity is going to move from the investigative phase to the prosecution and trial phase is indeed how courts will react when they will be presented with a body of evidence composed of elements coming from different jurisdictions, where they have been acquired according to the locally applicable standards, both in terms of compliance with legislative rules and the whole set of pragmatic applications and habits that those procedural rules carry with themselves in its jurisdiction. So from this point of view, you understand that it is the EPO's interest that each time these evidence-finding activities are carried out, they do meet the most advanced standards of protection of procedural rights. But on the other hand, we still face a situation where the lack of a commonly accepted standard as to what is the minimum content of guarantees that a system has to put in place for a particular acquisition of evidence to be considered in line with a commonly accepted regional standard is for us the source of a potential problem. Because it will be, we are essentially in the hands of national courts, as is normal. However, there is a variety of parameters that will present itself as possible key to the resolution of conflicts on these matters, which is something on which we have largely no control over, and which will be, to a large extent, a surprise. So from this point of view, we are primarily interested in ensuring that a reflection, be it in the sense of understanding how the different national courts think in terms of parameters for cross-border admissibility of evidence, or in terms of a reflection which leads eventually to the exercise of the power of initiative of the Commission under Article 82 of the treaties, is of primary interest. And from this point of view, I think that the EPO will be able to give an important contribution to this reflection, if only because it will be faced in its daily work with exactly the kind of issues that this reflection will have to address and solve. I would like to leave it here for the moment, but of course I'm available for all your questions.
Thank you. Thank you very much, Luca. It's really interesting to hear how these uncertainties in the legal framework are really creating such huge challenges for EPO in that sense of trying to foresee what will be admissible or not. It makes it incredibly difficult, and very interesting as well to hear the question you raised on what is actually cross-border evidence, especially in this digital evidence age where we hear that the vast majority of criminal investigations involve some form of digital data, which may well be stored or held in a country or by a company based elsewhere. So that cross-border element, I think, in evidence and the nature of evidence is really an interesting one that you raised. Thank you, Luca. And please, I just wanted to reiterate that to participants to put in questions in the Q&A that you may have, and that we'll turn to after our fourth and final speaker, Elisabetta Ivicevic-Karas. Sorry again for the pronunciation. Elisabetta is professor at the Department of Criminal Procedural Law and Vice Dean at the Faculty of Law at the University of Zagreb. Elisabetta teaches criminal procedural law, penitentiary law, human rights, and criminal justice at both graduate and postgraduate level. She is the author of many publications, and she also has direct experience as an expert within the Ministry of Justice in Croatia in the transposition of the four of the procedural rights directives, including in particular the one on access to a lawyer. And we're very proud that Elisabetta is one of our members of our Fair Trials Legal Experts Advisory Panel, the LEAP panel, as well as a member of the Croatian Law Center, who is a partner in this research. So Elisabetta, over to you. I think you'll be responding to the many different and fascinating points that have been raised to really open up this discussion on the role of regional standards in relation to remedies. So thank you, Elisabetta, over to you.
Thank you, Laura. Good afternoon, everybody from rainy Zagreb. I'm really very honored and happy to have an opportunity to join the discussion that we have today on evidential remedies and to try to contribute to drawing some conclusions. I'm also very happy to be able to communicate with the partners on this project that we've been, all of us from different organizations together with Fair Trials, we have been working on for almost 2 years now. So it is very nice to have a final conference and to have the opportunity to speak. I would start with a very brief looking back to the time shortly after the Lisbon Treaty, when intensive preparation of the legislative activities of the European Union began, primarily in the matter of fundamental defense rights. Namely, as we heard today, the principle of mutual recognition as a fundamental principle of judicial cooperation in criminal matters between the member states of the Union implied a harmonization of minimum procedural rights in order to strengthen mutual trust as a fundamental precondition for mutual recognition. So this intensive regulation of criminal procedural issues on the European level resulted in several directives, of which 4 regulate defense rights. 1 directive regulates the presumption of innocence and other elements of a fair trial. 1 directive is intended for children who are suspects or accused person in criminal proceedings. There is also a directive on victims' rights, which is also very important, although it is not in the focus of our discussion today. And of course, there's the directive on the European Investigation Order. And if we look only at how broad the area of regulation at the EU level is, we can of course speak about the criminal procedural law of the European Union. It is a term that is already used in literature, of course, with some reservations that we must include. Yet, despite all these efforts, in criminal procedural law, it is common for procedural violations to be followed by certain consequences. Those consequences may be of procedural nature, such as procedural sanctions in cases of more serious violations of procedural rules, as well as different extra procedural sanctions. And having that in mind, it is unusual that the directives on procedural rights do not provide for any sanctions for the violations of rights they guarantee, even the most serious violations of rights, which then in advance puts into question their impact on national legal systems. Today, we discuss about evidentiary remedies and the issue of legal remedies that should be available to suspects or accused person in order to protect the rights prescribed by the directives is closely related to the application of procedural sanctions provided by national orders for cases of violation of the defense rights guaranteed by the directives and then also by national laws. That is because procedural sanctions are actually applied either at the request of the parties in the proceedings when they use appropriate legal remedies, or ex officio by the court, usually by the court, which is in a position to assess the regularity or legality of particular procedural action and the evidence gathered by that action. In the theory of criminal procedural law, procedural sanctions are provided for cases of omissions or errors that occurred in taking procedural actions that cannot be immediately compensated or repaired during the proceedings. So on one side, there are serious efforts to harmonize national criminal procedural laws at the EU level through directives on procedural rights, while on the other side, the outcome of harmonization efforts will depend on how consistently the rights from the directives have been transposed into national laws and implemented at a practical level, and how effective the remedies for protection of those rights are. Yet, as we heard earlier today, procedural rights directives proclaim the right to an effective legal remedy in rather general manners. And the European legislator obviously relied to great extent to the standards established in the European Court of Human Rights case law. So procedural right directives contain in various manners articulated criteria of fair trial considered as a whole. We also talked about it earlier today, which is taken from the jurisprudence of the European Court of Human Rights. But none of the directives explicitly determines in which situation some of the most serious violation of the rights guaranteed by a particular directive would directly undermine the fairness of the proceedings as a whole, and thus cause specific procedural sanctions, including the exclusion of evidence as the most serious or most severe procedural sanction. It is interesting to mention that initial proposal for a directive on the right of access to a lawyer actually provided that the remedy must have the effect of placing the suspect or the accused person in the same position that he or she would have been in the absence of the infringement, which would then implicitly pave the way for the rules on exclusion of evidence obtained in violation of the right to a lawyer, which would be in accordance with the Saldus doctrine mentioned also earlier today from the case law of the European Court of Human Rights. However, ultimately, the proposal was dropped, and somehow in the meantime, also the case law of the European Court of Human Rights has turned to a different direction, especially after the Simeonovic judgment. So from the fact that the directives on procedural rights do not contain practically any rules on lawfulness of evidence, it is possible to conclude that the European legislator followed the example of the jurisprudence of the European Court of Human Rights, in which the issue of illegal evidence and procedural sanctions in general as a rule, except in those couple of cases that we mentioned earlier, which concern violation of Article 3 and use of agents provocateurs, they are left to national laws. Moreover, none of procedural rights directives proclaims a very useful standard established in the European Court of Human Rights case law, that the suspect or the accused person must have the opportunity to challenge throughout the procedure, meaning at the different stages of procedure, the lawfulness of evidence, which is, of course, an important tool for obtaining the exclusion of evidence in cases of the most serious violations of procedural rights. So this relying on the standards established in the European Court of Human Rights case law is a problem. On one side, it is a problem since we know that it was precisely insufficient harmonization effects of the European Court of Human Rights case law that first led to legislative efforts in the field of procedural guarantees at the EU level. On the other side, this reluctance of the EU legislator can be understood, as we also heard earlier today, given that the issue of procedural sanction is extremely delicate for national legislators, especially when we know that national legal orders and criminal procedures of EU member states are still very much different. And the attempt to impose common procedural sanctions, including explicit rules on exclusion of illegal evidence, could still be seen by states as a kind of threat to their sovereignty. Looking from the comparative legal perspective concerning the regulation of exclusionary rules, EU member states can be considered within 2 or maybe even 3 groups of states, although they have very different regulations of illegal evidence and exclusionary rules. So, as we heard earlier, there is a group of member states that use the balancing or discretionary or relative form of exclusion of evidence. In those systems, exclusion is mandatory only in cases of the most serious violations, primarily with regard to personal evidence, while the material evidence is rarely excluded, despite violations, if the illegality that occurred did not affect the credibility of such a particular type of evidence. The second group of member states includes legal systems which do provide for an automatic exclusion of evidence, but not for a large scope of violations. Comparing with the third group that I would add to our previous discussion, the third group of states, in which automatic exclusion of evidence, at least at normative level, includes really large scale of both personal and material evidence gathered through different serious and less serious violations of procedural rights, and even of some minor procedural formalities. That is the case in Slovenia and Croatia, where I come from, which are both EU member states, but also in some other states that are not EU members, for example, in Montenegro, Bosnia and Herzegovina, Serbia, and Northern Macedonia. A deeper study into each particular legal order would show the complexity of traditional, historical, social, cultural, and even political circumstances, at least in some states, that led to such regulation of evidence and unlawful evidence. So obviously there is a need for some kind of regulation, I would say on legislative level from the part of the European Union. We heard also earlier today that concerning the role of the Court of Justice of the European Union, that I believe that it actually could, in its case law, establish certain criteria for exclusion of unlawful evidence if it had the opportunity to decide on it, if such a question is raised by national courts. At the moment, we all know that the Court of Justice of the European Union applies the standards that are established in the case law of the European Court of Human Rights when it comes to guarantees of a fair trial. However, the question is whether the Court of Justice is ready to go beyond the standards that have been set in the jurisprudence of the European Court of Human Rights. So in my opinion, relying solely on the jurisprudence of the CJEU would not be enough to regulate the important issue of effective legal remedies, at least for most serious violation of procedural rights guaranteed at the EU level. And finally, although today the discussion was focused mostly on exclusion of illegal evidence as the most efficient procedural sanction in rule for serious, at least for serious procedural violations, I would like to point out that we should keep in mind that exclusion of evidence in many respects is not a perfect legal remedy. It cannot be considered as an effective legal remedy, for example, in cases where the accused person is acquitted or found not guilty, or when the proceedings were closed even before the stage of trial, or even before the person ever found out that he or she was under some kind of investigation measures and that his or her fundamental rights were violated. But even more in other cases, not only in cases where the person was actually not guilty, in all the cases, even the most serious or severe exclusionary rules as procedural sanctions do not always have to work well in practice. I can tell you from Croatian experience, as I mentioned earlier, Croatia has really very strict rules on automatic exclusion of evidence in many cases. When we transposed the directive on the access to a lawyer in criminal proceedings, we actually prescribed mandatory exclusion of evidence if the suspect who was questioned by the police was not able to have a defense counsel, if he was not properly warned of his or her rights, especially of the right to remain silent, if the whole questioning was not audio-video recorded. We have a provision that such questioning or result of such questioning may not be used as evidence in criminal procedure, neither can all the evidence that was derivated from this questioning. So this provision has very, very strong preventive purpose. There are several grounds why, according to my opinion, Croatia had to do that. Unfortunately, I don't think I have the time to elaborate all of them. But I would just like to say that the research that we conducted within this project in Croatia, with Croatian Law Center being a partner at this project, actually showed that in several cases that we did study, where the question of legality of police questioning of suspect was raised, the court actually, in none of those cases, did not use exclusionary rules and did not exclude that evidence, for the reason that the court actually was not willing to go to the phase that took place before the formal questioning and to actually investigate whether any irregularity, especially any serious violation of any procedural rights, actually happened at the earlier stages, before the formal questioning and before the audio-video recording. And as we heard this afternoon, this initial stage, before the defense counsel arrived, before there is formal proceedings, is, I would say, traditionally problematic, even before the Saldus case. And the post-Saldus jurisprudence showed that it is still a huge problem. And it seems to me that the directive did not solve it, even in those cases, if we would provide for the most strict a procedural sanction, which is exclusion of such evidence and all derivative evidence. With this, I would like to finish my intervention for today, having in mind the time, and thank you very much for your attention.
Thank you very much, Elisabetta. Thank you. That was a great way to wrap up many of the points raised today, and highlighting the need for legal regulation at the EU level, the fact that we can't expect regional courts to go far enough to regulate enough, but also reminding us that at the same time, even with a strict, based on the Croatian example, even with a strict legal framework, that doesn't necessarily lead to an effective remedy or perfect remedy in practice. I noted that you also raised earlier the need to ensure that challenges are possible throughout the procedure at pre-trial stage in particular. And this is something that we were also looking at as part of our research and our recommendations. And I have a question for, I think first for Fabian, if that's all right, that I'll let Ilse put to you in terms of a way of approaching this issue at an EU level. So I'll hand over to Ilse. Thanks.
Yes, thank you. I'll use the privilege of just being there to ask a question in person, so to speak. You mentioned, of course, the challenges of arriving to substantive standards on admissibility or exclusion, and this is something that I also mentioned in the first section, that we see that there is a risk, especially in cross-border proceedings, to legislate on a maximum standard of protection, which would risk to bring down a lot of protections on a national level that exist at the moment to a common lowest or a common sort of standard that the member states could agree to. But my question is on the other side, not on the substantive rules of admissibility, but more on the procedure, because we see that is a very difficult aspect, especially getting access to information about evidence gathering process. And what we can see, at least in the context of EAW, that the CJEU tends to narrow the scope of access to information in cross-border proceedings at the moment. The legislation exists, but remains inaccessible until a person is either transferred back in the EAW context, or in EIO context, it's even more difficult to understand what the procedure of review of legality of evidence would be. So would that be a possibility to legislate rather than on substance, which could be challenging, to also focus on the procedure that would enable effective reviews, focusing on access to information and determining the forum for, especially for cross-border evidence, for reviews, and to bring that side to a regional standard that could enable that effective review. Thank you.
Thank you. I think it's a very interesting and also very difficult question, because it's a very innovative way of tackling this issue that would be indeed taking the issue one step before we go to the exclusion, possible exclusion step. So first, the importance of being able to challenge the gathering of the evidence itself in a cross-border context, if I understand correctly what is at stake. It's true, so I'm not the specialist of EAW and EIO, but it's true that in those instruments as well, you don't have very strong rules also on remedies and how, especially in the EIO, for instance, how you should be able, one should be able to contest, to challenge the way the evidence has been collected in another member state. I know there are currently some cases before the European Court of Justice on the EIO the court, I think the case is called Gavonazov. It's if I don't if I pronounce it correctly. The court kind of escaped the question in the first case, and notice the national court has asked again the same question. And it will be very interesting to see if EIO should be interpreted as granting a remedy, against a measure or an evidence gathering measure. And I don't know if it's really possible to legislate horizontally on this issue, because it would lead de facto to an amendment of the EIO, basically, which will go a bit forward than what is already contained in the EIO. So let's see what the court will say, because depending on the answer of the court to this question, it might put at stake some systems of national gathering evidence which would not be compliant to the right to an effective remedy. And therefore, indeed, such systems will have to completely adapt and to put in place new remedies that should apply at this not very early stage, but at this early stage of gathering of evidence. So I know that this answer is probably not very satisfying, but actually this is a question that we can, I'm sure, continue to exchange on in the coming months.
Well, thank you, Fabian. That's great, and it is very much a discussion and thoughts that we were sharing in terms of how where we got to thinking originally, setting out with a project where we thought maybe looking at common EU standards would be the right approach, and then evolving into our thinking in that respect. So it's very helpful to have this discussion, and certainly, as Ilse said from the outset, something that we are very much open to, and it is absolutely necessary that we all do engage in this process, as we've heard from Luca as well, and from some of the participants in terms of the difficulties they face in obtaining remedies in national proceedings at the moment, where they sense that their rights, procedural safeguards are being violated and they don't have any remedies for that. So these are a really important topic, a very important topic that needs a in-depth discussion. So we're also looking forward to the study that the Commission will be conducting. Can I invite, because we're coming up to the end of our time, I just wanted to give the opportunity to Matilda to say a few words. Luca, Elisabetta also, and Fabien, of course, if you wanted to say a few final remarks, respond to any of the other presentations before we close.
Just thank you so much. It is so fascinating, and learning from you, listening to you, it shows how much it still needs to be done all the time. So thank you so much.
Thank you, Matilda. Luca, did you want to?
No, I cannot add much, except that this is an extremely interesting discussion. And again, for us, it's a privilege to be able to follow this and hopefully at some point contribute with our experience on the ground.
Yes, we look forward to hearing more about the experience once these cases get to court. And Elisabetta?
I can just add to thank everybody, the organizers, the colleague panelists, and everybody who attended this conference this Friday afternoon.
Thank you, Elisabetta, and thank you to you for your work and support during the project. And Fabien?
I will also just say a thank you word to all the participants, the organizer, and also to the persons that attended this event. I think we all are aware that there is still a lot to do on this issue, and the way to do that is obviously a collaborative way. So such discussion will help to find what are the problems and how to tackle them in law and in practice.
Absolutely, in law and in practice, as you say. So thank you very much. This was a fascinating discussion, and I'm very grateful for your contributions. And again, to reiterate the thanks that is already expressed to our partners for their brilliant work in this project. It's a fascinating area, and we're very pleased to have also been able to look into again the FROS research, which has been incredibly helpful, and to think about it in the context of this increasing cooperation in terms of cross-border evidence exchange. So it really is a very interesting topic. Thank you very much, and thank you to the European Commission who part financed this project under the Justice Programme. So thank you very much, and I'll hand over now just on time to Ilse for a few final concluding remarks. Thank you, and thank you to our participants.
Yes, I would just like to also thank all of our partners to the European Commission and all the speakers, and really just one sentence to finish it. To just our report is a piece of just a very limited piece, 5 countries and regional standards of factual basis for a further debate. So I hope that our report it's not conclusions, but more of a start to debate, and I hope that we can provide further assistance and engage in further discussions on our proposals, both with legislators, but I hope also that the methodology that we have offered reaches judges on all levels of courts, because it increasingly seems like the burden of ensuring proper protection of fundamental rights and also interests of administration of justice really rests mainly on judges. So we hope that what we have offered for discussion would ultimately provide a helpful guidance to them. And so on that note, I thank you to all the participants as well who joined in this session and the first session, and I'm hoping to see you all soon for a continuation of this debate. Thank you.